Interesting turn of events now. The Commission is resolved to lay criminal charges against Suliman Carrim, as we've heard from the Commission chair, that this brings to an end their back and forth with Mr. Karim at this point.
Unprecedented, Mfundo. I don't think the Commission has ever arrived to this point throughout its existence, where it's essentially drawing a line in the sand and is essentially now transferring what was meant to take place, or at least referring what it's found so far to the relevant authorities, with that criminal charge, we're told, now officially going to be laid by the Commission's secretary. And I suppose the message here is also quite clear. In fact, if you listen to the chairperson after making those remarks, you get a sense that they are also aware of the precedent that this essentially sets, saying that if they weren't to take the step, then the Commission itself wouldn't be taking itself seriously, and that might very well give other witnesses the impression that essentially if they eventually don't appear before this inquiry, then that's essentially where it'll end. Before we bring in Karim, let's take you back to the submissions that were made by Adila Hasim SC, the evidence leader in the stream, who, after making her own submissions, went on to essentially bring her prayer, if you like, towards this commission, saying that as far as they're concerned, they're going to ask the commissioners to consider the evidence that they already have surrounding Suliman Carrim. Take a listen.
The submissions I'd like to make on how we'd go forward, Chair and Commissioners. There's limited time remaining for this Commission to complete its mandate. At this point, we submit it's appropriate for the Commission to simply make its findings based on its assessment of the evidence that's already before the Commission. In the previous hearing at which Mr. Karim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The Chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the Commission now just makes its findings based on the evidence that it currently has before it, without any further...
What kind of findings do you have in mind? I'm sure you are not referring to the postponement application, because the ruling on that application was made on the basis of what was before the Commission at the time of the hearing of that application. So what sort of findings do you have in mind?
Chair, I'm referring to any findings to be made on the basis of the evidence that was led on the 9th and 10th of March. So it's on the merits of what the issues are, whether it shows any of the conduct that we were presenting at the time that we felt fell within the terms of reference of the Commission.
I hear you.
So it's those findings. So the evidence we have is the evidence we got.
All right, so let's bring in Karim, our senior reporter here at the Madlanga Justice College, who's been listening into today's proceedings. And Kenny, now the record holds so much weight, right? Absolutely. Because what we're hearing is that is what is going to be referred to the NPA for further consideration.
Well, absolutely. This is the first witness, or should I say non-compliant witness, that is going to be referred for the relevant criminal process to continue in terms of the breaches of the Commissions Act, because Suliman Carrim is effectively a no-show before the probe, and he has failed to meet the requirements for him to be excused today. It seems that the legal team of Suliman Carrim thought that they could thwart this process by bringing in another report by the very same treating doctor that the Commission has said, because of the very reason that this is a treating doctor, they need to get another independent medical examination to someone who is not close to Suliman Carrim to assess the situation. Of course, this was a voluntary process in terms of the kind of recommendations that were made, but the evidence leaders made it very clear that this latest postponement, which was today, the 14th of August, had to come with conditions to ensure that either they get some form of an independent medical report for Suliman Carrim, or the necessary consequences follow. I got the sense that when Advocate Adila Hasim SC started with her presentation, that the evidence leaders at this point had given up on getting any further evidence from Northwest businessman Suliman Carrim, and we're now elevating the steps to the next process. And as we see, they're successful in that regard, and Suliman Carrim becomes the first witness before the Madlanga Commission to not finish their testimony, and the Commission now accepts that they're not going to get the remainder of this testimony and can only work with what they have so far, not only in terms of the hard evidence, but in terms of his own testimony before the probe, and has now instructed the Secretary, Dr. Nolita Vuguza, to then institute the criminal process, and how that plays out is up to the relevant functionaries and how they choose to investigate this breach of the Commissions Act. But effectively what you've seen is the Madlanga Commission draw the curtains on the witness that is Suliman Carrim, because it's quite clear at this point that they're not going to get the remainder of that testimony or the requested information, even in the timeline leading up to today's basically a landmark decision in terms of the Commission's work, because he's the first witness to get this kind of consequence, is that leading up to it, there was no compromise or submission in terms of the lawyers of Suliman Carrim to heed to the request. What followed is that the very same treating doctor that the Commission has laid a distinction with because of their very role as the treating doctor, that this doctor then submitted an extensive report 2 days before we were set to sit here, which meets the deadline, but doesn't meet the deadline of the Commissions to test whether or not this indeed is the circumstance upon which Suliman Carrim faces. So I'm not sure if we can phrase it as escaping accountability in this regard, but you won't see Suliman Carrim before the Madlanga Commission. It's now up to the relevant authorities in our criminal justice system to see how they take this matter forward. But there is enough substantive evidence with regards to the SAP's tender and the WhatsApps to at least draw some links in that regard, but you won't get any idea as to what Suliman Carrim's own alleged business dealings tell you about alleged cartels, the alleged suspicious money flows, if there's any allegations or true to allegations of money laundering. All of those details are something that you're going to miss out on, but at least there is something that the Commission can work with respect to Suliman Carrim.
The ball is definitely in the NPA's court. I want to just also take us back, Kenny, to an aspect of that interaction between the chairperson and the evidence leaders, I beg your pardon, and the lawyers for Suliman Carrim. And it is quite, I think, the flow of consciousness from the chairperson. He went on for quite a while explaining why the report that they currently have in their possession today does not suffice insofar as what was required in that order that was given out on the 29th of July. It's worth listening to. Take a listen.
This medical report, which is now in front of the Commission, explains in particular what happened after Chair's ruling on the 29th of July and what was undertaken or not undertaken in that regard. And to the extent then there are references to historical facts, that's also dealt with in this report, and those 7 or 6 other medical reports which have historically been tabled haven't been challenged in front of the Commission, and they stand as an explanation for those outings,
you see,
one way or another.
Last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Karim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports? So it's a non-starter for you to talk about a lack of challenge.
That's
complete non-starter.
I respectfully disagree with you for 3 reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
It's not the doctor that the Commission wants to have assessed. It's not the doctor.
Be that as it may, it's a less intrusive means that's available to the Commission in circumstances where the purpose of the examination is to run a parallel process to verify those clinical opinions. That's the purpose of getting the patient into a voluntary medical examination. The point I'm making is that the doctor,
I'll listen to the rest of your rebuttals because you say you disagree with me, and I think you said on 3 bases.
Yes.
So the first one, I do not accept at all. You may continue arguing on it, or you may proceed to number 2 and number 3.
No, I won't. It's on the record, and that's sufficient for my purposes.
Okay.
The doctor's made himself available. Nobody's chosen to do anything about that.
Nobody wanted to assess the doctor. So
No, but
may I finish?
I apologize, Chair.
That's simply not an answer to my point.
With all due respect, though, I think we're speaking cross purposes because what Chair is saying...
We are not. I understand you perfectly, and I'm sure that you too understand me. To counter the question whether Mr. Karim is indeed unable to come to this commission, the commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the commission wants to have. It's not an assessment of Mr. Karim's specialist. That's a simple point I'm making.
Yes.
And for Mr. Karim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Karim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Karim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Karim's story.
All right, so there you have it. Quite the exchange between the lawyers for Suliman Carrim and the chairperson of the Madlanga Commission, Mbuyiseli Madlanga. Kenny Mapanga, once again, still keeping a close eye on these developments. At some stage, Kenny, the chairperson flat out says we cannot really trust Suliman Carrim's lawyer.
And it's not about his credibility or his abilities as a medical doctor or specialist. It's about the pattern that emerged when they were requesting this information, that when they were confronted with different facts, that the information would change accordingly. So when the CCTV footage showed that this, or rather Suliman Carrim was seen at a shopping complex in the Western Cape, at a Kauai, at a Woolies, etc., then the statement was changed to meet that different facts. Now, because of that occurrence, they wanted an independent medical report that could also look at the circumstances surrounding Suliman Carrim. It was not an indictment on the medical specialist. It was about ascertaining what his current circumstances were, because this particular medical specialist is too close to the subject at hand and would change the reports, or at least that's what the evidence suggests, to meet any different facts that the commission or the evidence leaders brought to them as they try to ascertain whether or not this health challenge does indeed persist and he's actually not able to come before the probe. But it's not unclear at this stage whether or not this particular ruling will be taken further or challenged further by Suliman Carrim's lawyers. But
Can they do that? I mean, in what kind of recourse do they have?
Well, this is a decision taken by the Commission. It is something that you could take up on review if you wanted to. And it's something that the Commission is expected to act on immediately. It's a decision that has some form of consequence for Suliman Carrim if those bodies decide to take this issue further. So it could be something that is pursued further by Suliman Carrim's lawyers. That's not something that we're in a position to ascertain at this point. But the back and forth surrounding what the Commission was willing to accept or not is something that gives you a clue about the position of Suliman Carrim's legal team at this particular stage. So we'll see how that plays out. But in terms of the work of the Madlanga Commission, I think that chapter is closed and the Commission is moving forward towards its evidence deadline of the 2nd of October 2026.
All right, we're going to put that on pause. Something tells me, of course, there'll be much to be said about that throughout the course of the day. But when we come back at 20 minutes after 11 o'clock, Drusanta Ramsamy is back in the hot seat.
Absolutely. The item IDAC state advocate that basically revealed all of the misleading evidence that Advocate Andrea Johnson, that is the former IDAC head, allegedly gave to the Madlanga Commission and the ad hoc committee about IDAC's operational methods and in particular its interest in crime intelligence matters. She has given evidence that gives a different layer to the lens in which there was an alleged target towards top cops such as Lieutenant General Dumsani Kumalo, the crime intelligence boss, and top cop General Fani Masemola, to the extent that IDAC is painted as a unit, or at least that little group that was involved in Project Diversion is painted as a unit that allegedly went at all costs, even if it meant committing alleged unlawful acts, which is pursuing cases without the necessary referrals and the authorizations, all in the bid to allegedly target these individuals, that is the top cops. And it seems, rather, apologies, that this may have been influenced allegedly by different elements that Jushanta is introducing. She has discussed the element of Major General Faraz Khan, which I think was ventilated in quite great detail by Advocate Silo as well. But she's also introduced another layer with the police minister, Senzo Mchunu, who handed over the IGI report that was not even complete and was confidential to IDAC in order for them to continue, or at least the inference is that it was allegedly to assist them with the investigations that were currently facing a lot of questions because certain individuals held the view that there was no case or merit to the Mukwele and the Lushaba matters. But it seems that this IGI report was given to them to allegedly assist them in that regard. And Jushanta has testified that that is not the manner in which it is supposed to be done. So it bypassed protocol, established protocol in order to do so. And the question is why? What is IDAC's role in this overall question of alleged infiltration and this bid to allegedly target these high-ranking generals?
Kenny Mapanga, thanks very much indeed for that. Kenny, of course, is our senior reporter here at the Bridget Mabanda Justice College. Quite an eventful morning so far. If Suliman Carrim's objective was to avoid coming back to this inquiry, some people will say he successfully managed to do that. But depending how the NPA now handles this matter, he may have very well gone from the frying pan straight into the fire. Time will tell.